The Supreme Court of Canada has made a landmark ruling on the issue of privacy rights.
It's found a high school teacher guilty of voyeurism after he secretly filmed some of his female students. Olivia Stefanovich reports.
In a unanimous decision, 9 Supreme Court judges agree students don't give up their privacy rights when they're at school, even though it's a public space. At issue in this case was whether 27 female students aged 14 to 18 had a reasonable expectation of privacy in their classrooms and hallways when their London, Ontario teacher, Ryan Jarvis, used a so-called spy pen to secretly film their faces, chests, and cleavage areas. The original court judge found Jarvis violated the students' rights, but wasn't satisfied the videotapes were made for a sexual purpose. Jarvis was acquitted. The Crown appealed. The Ontario Court of Appeal found Jarvis did act with sexual intent, but still upheld his acquittal, arguing the students had no reasonable expectation of privacy at school, pointing to the presence of 24-hour surveillance cameras. Today, the top court quashed that decision, and many privacy experts are celebrating.
I think it's a really important decision for Canadians' privacy rights going forward, in particular because the court again rejects in very clear terms the idea that being in a so-called public space somehow should be interpreted as a waiver of one's privacy.
But others are concerned. Jarvis's lawyers released a statement calling the ruling troubling, saying it casts the criminal bar too wide. Everyone can agree that the ruling has far-reaching implications. How they are interpreted going forward remains to be seen. Olivia Stefanovich, CBC News, Ottawa.
All right, for more on this, we're joined by leading privacy lawyer David Fraser. Hi, David. So your thoughts on today's decision, what do you make of it?
I was pleased. I wasn't surprised. The Supreme Court of Canada has been building a body of jurisprudence, of case law, that's really quite nuanced when it comes to understanding privacy and privacy interests. So this comes from the criminal law context, talking about what is a reasonable expectation of privacy and taking into account a whole bunch of different factors that recognize privacy isn't binary. You often hear it discussed in terms of either you have an expectation of privacy or you don't. But in this case, one of the facts is that we were talking about students. We were talking about something that happened in the school context. We're talking about it wasn't just kind of observations with the eyes kind of fleetingly as one would, but it was using technology. It was using kind of a covert camera. And so all of those things become part and parcel of what is an individual's expectation of privacy, which is relatively nuanced. Certainly kind of a yes or no answer is question is easier to address. But privacy is a different thing for different people, and you need to look at all of those circumstances.
Well, how is it going to affect privacy in other types of public places, say the shopping malls? What can people expect to have for privacy?
I don't think anything's going to change radically, but for people who make decisions about privacy, about surveillance cameras, about things like that, there's more nuance that they're going to have to pay attention to. I've previously heard arguments, for example, of where you put cameras up in a workplace and say, well, this is no different than having the supervisor walk through. Well, no, the technology is actually a little bit different. Is it recording? Is it not? Is it watched 24/7? Is it not? And so we need to ask these questions a little bit more. Also think about what are the power dynamics. A teacher and a student is a different sort of context than maybe somebody walking through a shopping center. But it does say, I've certainly heard people say, well, you have no expectation of privacy in a public place. Well, yeah, you do. And I think that this also is something that will hopefully be used to address a very creepy practice of individuals using small cameras to take pictures up people's skirts and in circumstances like that. And what this case stands for, the proposition that, you know, even if you're out in public, you have an expectation of privacy, particularly where it comes to uses of technology in ways that you wouldn't expect. So something that's within the normal field of view for somebody walking down the street, you know, that's going to be visible to everybody, and your expectation of privacy is lower. But if somebody has to kind of contort or do something else like that, you still have a privacy interest there.
Now, we've got new advancements in technology all the time, you know, maybe smaller cameras, maybe more surreptitious recordings. Do you expect to see maybe an increase in people sort of pushing the envelope of what kind of privacy they can invade?
Well, I think we're already seeing that,
Yeah.
and that's the reality in a number of ways. So, for example, 15 years ago, you wouldn't see surveillance cameras other than in banks. Well, now they're cheap, they're small, and they're networked, so they've become very ubiquitous. Same sort of thing. That who would have thought 15 years ago that we would all be walking around with a high-def video camera in our pockets, which we effectively do. And so certainly the technology moves. It's used for great things. The number of kind of pictures that I have of moments that I want to remember thanks to my camera in my pocket is just incredible. But those technologies can be used for intrusive purposes. And I think the Supreme Court's doing a good job keeping up, making sure that our understanding of the law is keeping up with it. And another thing to think about is the crime itself that the Supreme Court of Canada was applying was only recently added to the criminal code. We didn't have an offense related to voyeurism previously. Usually it was dealt with in terms of the trespassing and those sorts of things. But recognizing, no, that was in fact a gap that we needed to address.
Were you surprised he was acquitted by one of the lower courts in the first place?
I was, but I think in a sense, it highlights the discussion that has been taking place with respect to, well, what is an expectation of privacy, particularly when you're in a public place? The lower court ultimately acquitted because one of the elements is that it has to be done for a sexual purpose, and the court didn't see that was proven beyond a reasonable doubt. The Court of Appeal said, it's pretty obvious that it was a sexual purpose. The question was, what was the expectation of privacy? And the Supreme Court of Canada kind of addressed all of that.
Mm-hmm. So where is the line between security and privacy?
Well, it's always going to be what is reasonable in the circumstances. And so, for example, and one of the factors in terms of whether or not privacy has been invaded depends upon what's the purpose for the invasion. If it's kind of against the individual and it's for a sexual sort of purpose, then that measures in favor of it being an invasion of privacy. When it comes to security, it's not necessarily a zero-sum game where kind of you automatically lose privacy to enhance security, but it highlights we're going to have to ask these questions all the time, and in some cases we might need to ask these questions about decisions that we've already made with respect to, for example, cameras in workplaces. Is it appropriate? How do you deal with kind of shoplifting that takes place in change rooms? Because that's a very context-specific circumstance where probably the answer is you're not putting any surveillance in there, but you might have an attendant who watches the change rooms, those sorts of things.
It is an interesting discussion. Thanks, David.
It's my pleasure, anytime.